Hello and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets, such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today I will be joined by my colleague, Clint Brannon, a partner in our intellectual property practice group here at Williams Mullen, and we'll be discussing how to preserve your intellectual property rights with marking, with a particular emphasis on patent marking. Clint, how are you doing today?
I'm doing well, Janet. I'm excited to be here. I think we're going to have a good time. How are you doing today?
I'm doing well. I think this is going to be a very compelling topic, so I'm excited to be sharing this time with you. I will switch it to you because I know patents also have their own scheme and regime for, marking. And I know that very often patented products have patent numbers on them and, sort of indications that something is patented. So is there a reason that companies would, put their patents or their patent numbers on their products?
Yes, Janet. It's called patent marking, just like or very similar to trademark and copyright marking. And a lot of the rationales as to why it's done are very similar to the copyright and trademark world. So, one reason is from a legal standpoint, if you make products that use your patents, then you really should mark them because it can impact your ability to collect damages if you ever wind up in litigation over those patents. And so that's a requirement only if you make products, because obviously if you don't make the products, there's nothing to put your patent numbers on. Now that's the first and I would say probably most important reason. Second, it can, and this is very similar to one of the points you raised on the trademark side, is it can help protect your market position somewhat. If competitors are thinking about making a product that competes with yours, then usually they'll go out and sort of look at what the competitive marketplace looks like, and they'll see that your product is marked with a patent, and they'll do some investigation, and they may determine, well, we can't really enter into this space because we're going to run into their patents. Now that's not a guarantee because they may look at your patent and your device and say, hey, we can design a similar product that doesn't fall within the scope of the patent and still get it out in the marketplace as a competitive product. So it's not a guarantee, but it does help protect your market somewhat. And third, most companies find that there's a marketing value in and of itself to having patents on their products. Consumers like to buy innovative products and they like to buy the newest technology. And so with patents on your product, to a lot of consumers, that's a selling point, and it can help you, increase your market share potentially. And this even applies in the B2B space, not just in the consumer space, although it's probably more important in the consumer space.
Well, that's very helpful, Clint. And I think I will say that over time, I found that I see less and less products marked with patents or patent numbers. So, and I don't know if that has anything to do with the way commerce is going, but now that you've discussed, what would be some reasons to mark patents, what would you say what does a company need to do to actually mark its products? What do you mean by that?
Yeah, well, there are a lot of ways that you can do it. I guess in the old days when most patented products were physical goods, you could actually stamp the patent number on a metal part, for instance. It was just part of the manufacturing process. If it was a molded product where you put a thermoplastic into a mold or some molten metal into a mold, you could shape the mold to actually have the patent number on it as well. Those are expensive processes to implement and to change periodically, as you would have to do as your patents change. And so it's more common today to put patent markings on packaging. So if you look at the box of a consumer product, it will typically list the patents relevant to that product on the box. In the user manuals, usually with all the other disclaimers up at the front of the book, it'll include the patent language, and on web pages as well, particularly for electronic products and software, you'll find these on the web pages, if at least.
That's very helpful. And I think actually I did not know that parties were including patent numbers on their websites, which brings up a really good point, which you raised during the trademark and copyright discussion, is that, sometimes things may be moving more toward the service side of things in commerce in terms of IP that's created and invented. So to that point, in addition to noting patent numbers on a website, what are some ways that you would mark something like software that isn't actually physical?
Yeah, that's a very good question, Janet, and the answer is kind of similar to what we discussed earlier in the trademark side. In the old days, to get software, I would go to a software store, buy a package with a CD-ROM, or if I was 10 years before that, some floppy disks, and bring it home and install it on my computer. And during that phase of the software industry, you could mark on the boxes, you could mark on the disks themselves, on the media, the instruction manuals. When you loaded the software, there would frequently be a splash screen, and there still is on a lot of software. And you could have notices, including patent notices on that as well. So that's how it was done in the past. Now, more software is going to a software as a service model where you actually don't physically own the software. You access it on a cloud. It's not really in your possession. So how does a company that offers software as a service provide notice? Well, the website's one good way. We talked about that earlier. You can put it on the website for your products. When the software loads, you still have something like a splash screen typically that will include the information about the development, usually copyright notices. You can also put your relevant patents there. If you have an about section that the user can click on and read about it, it'll have the version number typically, and you can include relevant patent information there as well. And you probably aren't sending out physical user manuals to folks anymore, but you still probably have electronic files that provide the user guides, and you can put them in that as well. So there's still ways to do it. It's just becoming less tangible, which is, I guess, appropriate for rights that are intangible in the first place.
Agreed, absolutely. So you've spoken a lot about, what are the benefits and how you may mark a patented product. But I think one thing that would be helpful to know is when we do the marking, what is it that a party should actually include in their mark?
There's no specific requirement as to magic words, but you need to, if you have a issued patent that your product uses, you need to put US patent number and then whatever the number is. Frequently, products will be covered by multiple patents. So you would say covered by US patent numbers and then list all your patent numbers. If you don't yet have an issued patent, you can say patent pending. And so that's very common. You see that on a lot of new products because the product is launched, they've filed a patent application, but patents take 2 or 3 years to go through the process and issue. So it hasn't issued yet and they don't have a patent number. The interesting thing is you can start using patent pending as soon as you file that application. So it's really, there doesn't have to be any sort of test as to novelty or usability of your product before you can start claiming patent pending on it.
That's very interesting. That's very different from the trademark and copyright side where you actually have to have a grant of something. So that's definitely a difference. One thing that you spoke about, which may or may not be similar to the trademark or copyright side, is how does marking impact, litigation, specifically your ability to collect damages, say, in an infringement suit? How does that work, and how is it different or similar to the other side of things?
Yeah, so they're certainly related concepts. The first thing I would note is that on the trademark side, the rights are generally sort of use them or lose them. If you're not actually using your trademark rights, then you're not going to have any rights to enforce. Patents are very different in the sense that I can get a patent on a technology and for whatever reason not use it, but I still have the right to keep other companies from using my technology. And so the notice and marking requirements for patents don't require you to mark, but if you do make a product that uses the patent, then you're required to mark in order to collect pre-suit damages. And it is the same notice type issue. The idea is that someone would see that the product is patented and they would be on notice of your patent, at least is a legal fiction, even if they didn't technically look at it. And so that allows you to collect damages for any infringement that they commit. Now, There are other ways to provide notice besides marking. So even if you've failed to mark, you can still cure that by sending them letters and providing them actual notice. But it's best to mark if you're thinking you might enforce your patents.
Well, it sounds like there are definitely a lot of benefits to marking and a lot of helpful, beneficial reasons. Are there any downsides to marking?
There are some risks, certainly. There's a statute that governs what's called false marking. And that's when you mark your device with a patent that isn't actually, the device isn't actually patented. So that's putting a patent on there that the device doesn't use, or doing things, otherwise putting lots of expired patents on there just to kind of discourage competition. And there was a fair amount of litigation on false marking 10 or 12 years ago, and it went on, for a couple of years. The law is pretty clear now, though, that, and the statute's consistent with this, that you essentially have to be purposely marking falsely in order to deceive the public or deceive your competitors. So it's not a situation where if you accidentally put one patent on there that didn't belong, that you're going to get in trouble, or if you don't, you have to affirmatively be trying to trick people, which is very unusual and I've frankly never seen happen.
Yeah, I think that point is very similar to the trademark side of things in terms of how false marking is seen, but there does seem to be some risk to false, involving false marking claims. So how would you advise companies to minimize the risk of false marking claims?
Well, if you want to completely eliminate the risk, the easiest thing to do is simply not to mark at all. I would say that's sort of risk avoidance or risk aversion rather than risk management. So I think what you should do is just make sure that you have procedures in place so it will be clear that you are not trying to deceive the public. If you make patent reviews part of your product launch and refresh cycle, so that when you're changing the paperwork for the products, the manuals, you're changing how they function, and you have to get new certifications from regulatory authorities or get whatever approvals you have to go through to launch your product, just make sure that you include a patent review during that process if you're marking. So if I launch a new version of my product, I'll just look at the patents that are marked on it, take any off that don't belong on there anymore. Maybe I've redesigned the product and it uses a new technology. And maybe I've had some new patents issue since I last did this a couple of years ago, and I'll add those on there as well. And it's really, you can sort of fold this into your product development and launch cycle fairly easily.
Well, that's very helpful. And you did mention, updates and improvements. So unlike trademarks, which can last forever, I know patents have, specified legal life term. So when we talk about, changes, updates, how often should you update, if at all, your patent markings?
Well, if your company has sort of a regular product refresh cycle, maybe every year or every 2 years, you're launching redesigned or new products, that's a great time to incorporate this process. If your product sort of stays the same year after year and doesn't really change, it's still a good idea to just take a look at it every 2 to 3 years if you have a large patent portfolio, and just make sure everything's current. It doesn't have to take a lot of time, but it's something you should do periodically if you're marking with your patents.
Well, thank you, Clint. That was very helpful. I learned a lot today. And it's interesting how there's a lot of crossover between patents, trademarks, and copyrights, and where some of the digressions are, particularly the patent pending, which is not, trademark pending is not allowed on the trademark side.
Yes.
Yeah.
Well, you see many, many products with patent pending, and I could file a patent application tomorrow and start saying that my product is patent pending the next day.
That will wrap up our discussion about patent marking. I'd like to thank Clint Brannon for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast, and read our legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.